Hello, classmates. I'm going to discuss topic one regarding former Detroit Lions football player who's suing the NFL for $5 million because he feels the NFL withheld knowledge about the dangers of concussions from the players. As an NFL executive, I would take the stance that he knew and agreed to the terms of the class action lawsuit and willingly waived his right to sue the NFL individually. So I would hope that this case would be dismissed. Not just because of that, but also because of the image problems that it presents for the NFL. As it is, you already have former players suing them. You do not need individual players again trying to sue individually when there's already a class action lawsuit against the league. Especially a lawsuit that involves damages for wrongful death, several varieties of fraud and negligence, according to Goldberg. These are the claims that the defendants are claiming against the NFL. As far as does he have a case, I would argue that under tort law he has a case for negligence. Bernstein states, in order to establish negligence claim, a player must prove the following elements: the league owed him a duty of care, the league breached the duty by its action, the league's action was both the actual and proximate cause of the injury, and the player sustained damages. In addition to holding the NFL directly liable for its own negligence, by establishing these elements, a player could prove that the NFL is vicariously liable for the negligent acts of its employees, i.e. the coaches. There's a couple of points I want to make now as far as these statements. Does the league owe him a duty of care? I think any employer, there is a duty of care to its employees. Also, the league breached the duty by its action. I think by withholding the information that the NFL had about concussions, I think they breached that by withholding that information. Now, on the third one, the action was both actual and proximate cause of the player's injury. Now, you can say that the player caused the injury by what he was doing or the action that he took. But that can also be related to the coaches. The players argue that the coaches instructed them to tackle in certain ways that were dangerous, to lead with the helmets, which was called spearing, which was banned from the NFL. So you can also place the onus on the coaches and the way that they instructed the players to tackle that put them in harm's way. Now, also going back to the coaches, Kane states concussions might represent one of the injuries that trainers send their patients back on the field with before players are completely healed. Thus, if a player lacks adequate knowledge of these risks attendant to returning to play before his concussion symptoms have subsided, he can be considered to have knowingly and voluntarily assumed the short and long-term risks of such injury. I believe this is the best option, going back to whether the NFL mentions all the potential harms that players can have from the concussions. For many years, the NFL denied any direct link to head trauma and any links to CTE. And they finally came out and acknowledged that, yes, constant head trauma can lead to CTE. So if the players are to argue on the basis of those grounds of the NFL withholding information and coaches instructing them to lead with their head, and doctors also sending them out before they're ready to go back, I think in terms of negligence, they definitely do have a chance of winning their case. That's what I have on this topic. Thank you very much for watching.